Welcome to Emory's Trial Techniques program. I hope you're finding a place to stay warm and safe as the snowstorm is coming upon us. There are some things that I need to tell you about the Trial Techniques program that I would have done had the class not been canceled. And I have to get this information to you before you go to your workshops on Friday. And the reason that we can't move the workshops back is because, as you might imagine, the firms have already gotten their faculty together and they have decided how it is that they are going to organize them and who their faculty is going to be, and their schedules have all been cleared, and so we have to stay on schedule. So let me tell you about the program. Let me tell you some administrative things and make sure that you know what resources are available for you to help you get ready. In some ways, what is going to happen here is what will happen in the other weeks, or would have happened in the other weeks, where you don't have a group session together with me before you go off, and you will have to get the resources that you need from our library of videos, the SRS videos, from the normative guide. The normative guide tells you in a text way how it is that you're supposed to do and conduct the exercises. And of course, in addition to that, you've got the resources of the people who are in this program who are available for you to give you answers to questions that you might have. Let me just say a couple of things about the people. First of all, I need to introduce myself to you. I'm Paul Zwier. I am the director of the program. I'm the academic director of the program, and my background is in trial advocacy from work that I've done with the National Institute for Trial Advocacy really since the beginning of my teaching and lawyering career. The National Institute for Trial Advocacy, NITA, was an organization that was put together because there was this feeling that trial lawyers needed some help with their advocacy skills. Warren Burger, Chief Justice of the Supreme Court, really got the American Bar Association to fund a series of learning by doing programs for trial lawyers to help improve trial lawyer skills. And this was in the late 70s, and out of that grew an effort that was also taken into law schools. And a fellow named Abe Ordover, who was here at Emory, was one of the first folks to really say, this is the kind of thing that Emory should be doing, and in fact, it has become a hallmark of the Emory program. The KEP program, the Kessler-Eitzen Trial Techniques program, is named after Kessler-Eitzen, who were folks who had taken the program, and then in fact, what happened is that Mike Eitzen, he was so committed to the program that when he lost a colleague of his, a woman who he had worked with, when she died in a plane crash, he endowed this program to ensure that in fact we would be able to continue to provide you with this trial advocacy training program. Now, the people that have come through this program over the years are some of the best trial lawyers in the country. And many of them come back each year during the May program so that they can go ahead and pass on to you the things that they have learned about being a trial lawyer. What we do is we have the spring workshop sessions so that you can go to the firms and in fact get you ready for what will happen in May. And what will happen in May, as you know, is another set of workshops about trial ad, and it culminates in a jury trial that occurs on May the 6th. And everything really is designed to head toward that time when you will do that trial. So the structure of the program is to give you opportunities to be on your feet, to practice, to get feedback. And as you get that feedback and as you prepare at a different level and a deeper level, then you will find yourself more and more able to and ready to be a trial lawyer by the end of this program. And we will give you this guarantee: if you bring your A game to this program and you work hard and you prepare, you will be a competent and skilled trial lawyer by the end of the program. Now, I know many of you are in this program and you say, well, I don't want to be a trial lawyer. I'm not interested in being a trial lawyer. And it is required for a couple of reasons for you to take this class. One, the requirement stems from the fact that we believe that advocacy on behalf of a client is at the heart of whatever any lawyer does. Whether it's advocating in front of a board or advocating in front of a regulatory agency or advocating in a transaction, that at the heart of that is an adversarial process where you are representing a client and you need to speak vigorously and passionately and skillfully on behalf of that client. Now, the second reason we want to take you through this trial techniques process is because no matter what your setting, you are often going to be advising people about trials, about what happens at trials. It's almost like emergency medicine for doctors, that to be a doctor, you need to have time in the emergency room, understanding what goes on there, what happens when things go badly and people are in crisis, and then you need to provide services. And so this is our version of an emergency medicine for doctors, but an emergency medicine for lawyers. This is what happens when you go to trial. And what are the dynamics of that? And that any lawyer needs to be competent about that. And it's why it is a required course here at Emory. It's something that is required for everyone, and it has become a hallmark. It's one of the experiences that you all share. And it becomes a marker for an Emory lawyer to have gone through this program and to understand the dynamics of it, the stresses of it, and to work on their public speaking skills and to learn by doing. So let me back up and just say a couple of things about the people that are here that are designing this program and putting you through it. First of all, you will see that the administrative director of the program is a fellow named Lindsey Jones. Lindsey Jones, Judge Jones to you, is a very skilled trial lawyer and judge. He headed up a legal services effort in the 80s and 90s on behalf of civil rights practice, establishing legal services for especially poor and minority people in North Carolina. And he has that skill in advocacy as a trial lawyer and now as a judge here, and he brings that to help us keep everything running on time. He is primarily the person you should look to if you have issues about attendance. He has heard lots of different excuses as you go along. I want to just flag a couple of things with you about that. One is the program no longer can allow for an unexcused absence. And let me explain why that is. First, it turns out that because these lawyers who we work with to provide you with instruction organize their time, they clear their calendars, they give up billable hours to be with you, it just can't be now that we have a significant no-show from you. What that means is that we just can't have you for whatever your independent reasons are deciding that you're not going to attend. It means you will have to give the firms notice if you're not going to be there. That you have to do that as a professional courtesy anyway to let folks know. And then that you have to clear the reasons for your not being there with Lindsey Jones in order to be able to make up the materials you will miss in terms of what substitute things you will have to do, but also to ensure the integrity of the program that everybody needs to be there. Now, there's another reason for us to do this way, and that is because the program is not graded, but the program is designed to give you a sense of professional responsibility, the kinds of things that you need to do and learn in order to competently represent a person in a courtroom setting where they're putting something on the line, some of their money or their risks. And so what you need to do is, this course, you can fail by blowing it off, not attending. You can fail the course by not being prepared and being competently prepared in what it is that you do. And frankly, one of the reasons that you can get into some difficulty in the course is if you so mail it in that you impact on, frankly, the skills and the efforts of your colleagues in these workshops. And let me just say a word about that. A few years ago, I was told the story of a young woman who came into a workshop at a firm, at a major firm in downtown Atlanta, came in 15 minutes late, dressed in flip-flops and summer attire, put her feet up on the conference table where everything was going on, and announced to the room that she was totally unprepared and she had no idea what she was supposed to be doing. Now, let me just say that the main thing I'm worried about in that situation is that, in fact, a student who had come that day prepared to give one of their best directs or crosses in order to impress that firm is harmed by that behavior. By not showing up and being prepared and being professional, what effect that has on your colleagues is to put them in a position of looking bad, making the firm say, why are we spending our time and our resources on this if you give it so little attention and time? And so it's important for you to realize that part of the firm dynamic is for you to act like a professional, dress like a professional, and to be prepared like a professional so that you can all learn and grow together. And it may not be for you, but certainly it could be for one of your colleagues, and help them look good by making sure that you don't detract from the educational experience that's going to take place at the program. Now, in addition then to Lindsay Jones, let me just tell you that the assistant director of the program is Ronnie Lott. Ronnie is one of our best and brightest here, a Woodruff scholar. She practiced law at Hunton and Williams. She is a very skilled administrator and trial lawyer herself, and she also is part of the support system. In addition, you know, there are 3L coordinators. Varana Hadinajad is one of the 3L coordinators, and then Samantha Rayburn is the other coordinator. Both of these folks are wonderfully skilled people. You will see them. They're very helpful. They can give you advice because they've become accomplished in trial advocacy themselves, and they will help you make sure you have the resources you need to get through the program. Now, I also wanted to mention that we have a group of students here who are looking for their master's in comparative law from Jiao Tong University in Shanghai, and Wai Ping Sung is their administrative support person, and they are here to work with us, and you may see Wai Ping around and certainly realize that she brings skills. She's an evidence professor in Chinese law, and she is a skilled professor and teacher, and we're really grateful that she's part of our support in this program. So those are the people who you will be working with. Let me say a little word in addition about your preparation. So there are a couple of sources you need to look to for your preparation. I mentioned one already, that is the normative guide. That's the text that's in the materials. I also want to tell you that as we move through the program, we go first in a direct and cross workshop, then second we'll have a workshop on exhibits, third workshop will have a jury selection component to it. The fourth workshop is a presentation to a client. It's a counseling session that presents to the client the strengths and weaknesses of the case. And then we will all come back here for experts, and the expert part of the program will be something that will be introduced on April the 1st at a workshop all together back here. Then, as you know, we will go on April 30 for the first part of the program in the May, we think of it as the May term, so April 30 through May the 6th, which is where we'll do the day-long workshops that lead to that jury trial. So that's an overview of it, but I wanted to say to you that the normative guide is your first text for the first part of the program. When we turn our attention to experts, then you will pick up the Effective Experts book. That will be your text. And note that what we have for you in addition is these SRS videos that are put together for your seeing demonstrations and getting some instruction on each part of these workshops. So you will get a little bit of a lecture, a mini lecture on jury selection, for example. You will get a little mini lecture about exhibits. You will get a little mini lecture about impeachment. And these little lectures are done by some of the best and brightest trial advocacy teachers and judges and trial lawyers in the country. Then you will also see little demonstrations of parts of the very problem that you're working on, the Love versus Regency problem. And so please take advantage of those videos. They are designed to get you to think about what you're going to do. And ask yourself, do I want to use that? Do I want to steal that? Or is that something that I want to change to make it part of my own style? Don't just blindly copy it, but please look at what it is that you see and see what it is that you like about it and what you think you can use, and make decisions about it for your preparation purposes so that you can make sure you understand what's going on, and then go ahead and use and copy if you feel like it will work for you. Part of your preparation then is reading. Part of your preparation is to watch the videos and to listen to the video lecture vignettes that are part of the instruction process. And as I said, that as you go through the process, this is kind of like one of those mass open online courses where you'll have resources that you'll be able to pull on at your leisure to get you ready for the workshop that you will be attending. As I said, the workshops are set up for you to perform. And you'll see that when you get to the firm, you will be divided into two groups of somewhere between 10 and 12 students in each one of the groups. Half in the group will be on one side of the case representing Regency. Half will be on the Love representing Dr. Love. And the idea is that during that workshop, for example, the direct and cross workshop, that you will do the direct examination of Dr. Love. Now, who's going to be the witness? And listen, please, that you, if you're assigned to do the direct examination, you are also assigned to be the witness, Dr. Love. There's a lot of reasons, there are a number of reasons for this. First, it's because, in fact, being a witness, you learn a lot about direct examination. You learn a lot about how it feels to be a witness. And so we want you to take that preparation part seriously to make sure that what you do is you will prepare that witness like you would in the real world. And of course, not all information is in that witness profile. You'll have to make some things up. Just make up things that are consistent with what you see that person to be in the real world. Don't make up any fact that is inconsistent with one of the issues that really is significant in the case. So part of your preparation, if you're doing the direct, and this will continue throughout the program, anytime you're assigned a direct, you're also assigned to play the witness role. So you get to the workshop, and the direct examination will be conducted, and the workshop leader will call one of you to perform to start the direct examination. You will probably perform 7 or 8 minutes. Now you need to prepare the whole direct. The reason for that is because if you don't go first, it may be that the workshop leader will ask you to pick the direct examination up from where the first person left off. That's to the workshop leader's prerogative. They could say, no, start over again, let's do another beginning, and let's just see how that goes. But you should prepare the full direct examination in order to be able to be prepared for the workshop. If you're prepared on the cross examination, I suggest that you prepare 2 or 3 points of cross. Now, eventually you're going to want to hear all the cross for the May term, and so you may take it upon yourself to go ahead and prepare the full cross examination. In fact, one of the most important experiences you'll have with cross-examination is learning how to order the different points in the cross to make sure that you have some success. But you will only have time to probably get to 1 or 2 points on the cross during the time that's allotted, the 7 or 8 minutes that you'll have to do your part of the workshop. After you perform, whether it's the direct or the cross, then the workshop leaders will stop, you'll go out of roll, and they'll give you some feedback. They'll give you some feedback about how it is that you did in the examination and what you might do better for the time that you do it when you're in May. And the idea here is to give you skills that are transferable, not just to the doing of the direct or the cross of this witness, but the skills of direct and cross generally, as you're thinking about being a trial lawyer on that issue or on that point. So the design of the workshop is to learn by doing, giving you a point or two of things to work on for the next time. And in the course of watching the workshop, feel free to take and borrow and steal from your colleagues as the direct examination is done. You will have the combined wisdom of the group of you thinking about that direct examination the different parts of it, and you will see performances and critiques, and paying attention to the full direct will give you the background you need to do the direct again when you have to do this direct of Dr. Love for the trial in May. All right, so that's the workshop structure. A couple other things that you should note. You will be encouraged, all of you, to object during the workshop. Part of your preparation in these cases will be that if you're doing the direct examination, to anticipate what the objections might be, especially if there's hearsay, especially if there's something about relevance or a 403B, overly prejudicial for its probative value. So your preparation in any one of the workshops will include an understanding of some of the evidentiary issues. Now, I know, and the workshop leaders know, that many of you have already taken evidence, and for you, this is a great chance to remind and integrate that learning into the trial itself. Others of you are taking evidence right now, and so you might not even have gotten to hearsay yet or relevance. And we understand that, and the workshop leaders understand that. At the same time, part of any preparation process is to anticipate what the objections may be. And by having all of you object and think about the objections, you also together learn and get more sophisticated about how to deal with objections. And so instead of looking at each other and saying, well, I won't object if you won't object, what we're going to encourage you to do is to go ahead and object. Put those issues on the table. Stay in roll. You will hear a ruling from the judge on the objection, and may ask you for a limited amount of explanation or argument on the objection, but for the most part rule and have you go on. And the idea is that collectively in that experience, you will learn a lot about evidence, objections, and how to manage those interruptions as you're making a presentation. So part of your preparation should include the objections and the learning by doing. Because the way the workshop works, there won't be time for you to be told all the things that you're doing well, and you should just take it for granted that you're doing many things well in these. And I just encourage you to realize the confidence that you will get from doing it, the experience of doing it will give you great confidence. Often you hear that some people are born trial lawyers. They seem to love the adrenaline rush of the trial experience and they thrive on it. At the same time, in this setting, there's lots of things coming at you, and even if you are born to it, it may be that you want it all and you need to think about it in more of a segmented way. Others of you are going to say, boy, there's a lot going on and I don't like the public speaking part of this. And the workshops are designed not always to give you the time and the feedback to encourage you in everything that you're doing well. And so there's a fair amount of critique that's going on. That is, suggestions as to how you can be better. I want you to know what kind of preparation has gone into these workshops. In each one of these workshop settings, I've held teacher training sessions with each one of the firm people to make sure that they spend their time giving you feedback that is designed to be constructive and is designed to make you better and help you get better. But that means that their time and their focus is on making you better, not always on taking the time to give you feedback on all the things you're doing well. So be prepared for that. Realize that that's what's going on. If you have an inquiry of the faculty about what you did well and whether or not there is something more that you should be doing, or you tried something out and you'd like some feedback on it, please realize that that's great for a break, and we want you to do that, but that in fact during the workshop itself there will only be a kind of time for pointed critiques to help you get better. Each one of these critiques will be designed to be given in terms of a head note. They will play back what you're doing. They will then give you a recommendation as to how to get better, and they'll give you a reason for why you should do it. And that format, that coaching format, is designed to really help you understand the point they're giving you and help you make it portable into a variety of other circumstances and settings. So that's information you need to know about why it is that maybe most of the time you're hearing about things that are designed to help you get better as opposed to the things that you've already done well. Now, there is couple things to think about before we stop here, and that is the getting to the firms, the logistics of getting to the firms is something that you do need to manage and plan for. Before you go to the firm, please make sure that you have gone to the website and you understand the logistics, the issues of where you're supposed to park and how they're going to handle the parking situation, or if you're going to try to take the metro down, where you get off and then what direction you turn, so that you show up at the firm some good 15 minutes early before the workshops start, so that you can start on time and that you make yourself in a presentable way. I know the first time is the roughest time, so build in some time to make sure you get to the firm on time, make sure that you get there and you're ready to go. Number two, urge you, again, if you need to miss, please clear that with Professor Jones, with Judge Jones, and make sure that you give the person at the firm notice about whether you're going to be there or you're not going to be there. And then finally, make sure that as you're conducting yourself in these workshops, please try to bring your A game. That the more you put into it, the more you're going to get out of it. And that I can guarantee you that in this process, you're representing Emory generally, and that the impression that folks have of Emory, and it's overwhelmingly positive. I've just visited these firms and they're very excited about your coming. And so please remember that you comport yourself in a way that makes us all proud. And if you do those things, you will find that this trial advocacy program is one of the most rewarding experiences that you will have here at the law school. I'm going to remind you of some of these points and send it to you in a memo, just so that you have those things in writing. I'm also going to give you some very specific reminders as we go along about what you should do before each one of the workshops. I want you to know that our 3L coordinators and Ronnie Lott will provide you with a little question and answer session before the workshops each week, so that you will have a chance to get any questions answered that you need to have answered as you go along. And I urge you to take full advantage of them and their resources. We've got an all-star program for you. The May term in particular has some of the best people anywhere in the country. Frank Rothschild and Ed Stein, who wrote your case file, will be coming. They're spectacular trial lawyers. Judge Ann Williams from the 7th Circuit Court of Appeals will be with us. She is going to be part of the trial program. Reuben Gutman, who is one of the best whistleblower lawyers in the country, will be here, as well as you know, some of our really famous Atlanta folks, Liz Markowitz and Mike McCoy. We've got a very strong faculty for you, folks from big firms like a guy named Mike Ginsberg, who is the head of the Jones Day litigation practice and training programs. He will be here. We've got small firm folks, plaintiffs folks, criminal defense lawyers, prosecutors. We've got a really great group. Steve Grimberg is from the U.S. Attorney's Office, and he is here. Mike Washington, who is a judge out in San Diego, he will be here. Zelda Harris, a wonderful trial lawyer and trial advocacy person, is also coming as part of the program, and I'm sure I'm leaving somebody out. So I want you to know that we've got an all-star cast that is coming. It should be a great program this year, and I'm looking forward to working with you on the program. Thank you.